Right, we are now live. Welcome, everyone. My name is Nipa, and I am a hotline specialist at Housing Court Answers. And today we are having a training on consumer debt. What is consumer debt? Well, if you don't know, today we have Aaron Scheinwald. He is a supervising attorney at Access Justice Brooklyn, and he will explain what that is. So, thank you so much, Aaron, for doing this. And now I'm going to hand it over to you.
Great. Good afternoon, everyone. I'm Aaron. I am an attorney at Access Justice Brooklyn. Before working at Access Justice Brooklyn, I worked for 7 years doing Sandy recovery, actually, which is, I think, at this point, dating myself, at New York Legal Assistance Group, doing FEMA appeals and FEMA benefits issues, homeowner insurance issues, flood insurance issues, issues with contractors, issues with SBA loans, whole range of things. So I have lots of different experience, but one thing that I have never been is a housing attorney. But we see tons of cases in civil court on rent arrears, especially since COVID. And I'm excited to talk to you all and maybe learn a bit from you as well. So what we are going to do is I'm going to tell you a little bit about what Access Justice Brooklyn does in case we're an organization in the future that can be of use to anyone here or anyone who is viewing the training later. Tell you about what we do, tell you a little bit about, as the title of the slide deck says, credit reporting, and then a little bit about debt collection, a little bit about protected income, and then a little bit about civil cases because they differ in many substantial ways, as some of you may know, from landlord-tenant cases. So let's get into it. So, as I said, I am part of Access Justice Brooklyn. We were founded in 1990. We were the Brooklyn Bar Association's volunteer lawyer project. We have since been spun off into our own organization. We're not formally associated with the Brooklyn Bar Association anymore, and we have several staff attorneys in our organization and also use a pro bono model to leverage our resources to provide as many services as we can to as many Brooklyn residents as we can. We are obviously a Brooklyn-based organization. We're happy to talk to everyone today, of course, about issues across New York City and potentially Long Island and Westchester as well. But we ourselves focus on Brooklyn. So we are working primarily in four areas: family law, advanced life planning, foreclosure defense, and consumer protection, which includes bankruptcy work, to help Brooklyners access a more accessible legal system and ensure greater justice for Brooklyners. So we have direct services that we provide, like through staff attorneys such as myself. We have education, we have outreach, and we are working in those four areas that I mentioned now and are set up here. So we do advanced life planning and senior assistance, which can include things like healthcare proxies, living wills, powers of attorney, and wills, those sorts of things. Consumer debt and bankruptcy. So we're in court 4 days a week in the pro se consumer credit part. In Brooklyn Civil Court, working on consumer debt defense. And we also do bankruptcy related to foreclosure prevention and for consumer debt. We do family stabilization work. We do homeowner assistance work, which primarily means foreclosure prevention, but can include lots of other things. And then we do a lot of senior education and outreach as well. Sorry, there's a little bit of a lag on my end our slide deck, which is probably my computer, so I apologize for that. So again, if we're ever useful to anyone in the future, we are a Brooklyn-based organization. Generally, although consumer credit through or consumer debt assistance through the Volunteer Lawyer for a Day program in Clara, which I'll explain in a little bit, has a higher income guideline. Generally, we're talking about people below 200% of the FPL. We have lots of volunteer attorneys from law firms, solo practitioners, retired attorneys who work with us as part of our old sort of legacy relationship with the Brooklyn Bar Association and our pro bono model. We help lots of people ourselves through our direct services, but we also have pro bono attorneys who are available to help. And at the bottom, that is our contact information. You can give us a call or you can start an online intake either for yourself or for someone else if you're a housing counselor who is helping someone with one of these issues and access our services. All right, so Let's talk a little bit about credit scores. I'm going to keep an eye on the time as we're doing this. These are going to be some basics for everyone about credit reporting and credit scores. Some of this may be things you already know. We're going to be taking questions, which Nipa may have said, but I don't remember, so I'm going to say it again. We're going to be taking questions as the discussion progresses. So if you have questions, then please feel free to put those in the chat, and we will pick those up. If they're relating to the material that we have in front of us that we're discussing in the moment, then we'll take them there. If there are some other things that come to you, then those can be questions that we can deal with at the end. All right, so credit scores are things that everyone knows about, generally speaking, but in terms of the basics, a credit score is just a number that measures relative to a specific credit product or individual who's accessing credit information if you are considered to be a riskier borrower or a safer borrower. And it is essentially supposed to be a measure, although imperfect, of how you pay your bills. Do you pay your bills on time? Do you pay them regularly? Do you have issues? What kinds of issues do you have? What kinds of credit issues do those issues relate to? So on and so forth. So your credit score is generally going to be in the 600 to 800 range, but credit scores range from 300 to 850. And if you are a quote subprime borrower, then that would be someone who would have a credit score of 620 or lower. And if you are considered a subprime borrower, then you, of course, may have some issues getting credit. That may not mean that you don't have access to credit at all, but it may mean that you have access to different types of credit. And obviously, we all working with individuals who may have issues with paying rent or issues with paying their credit card bills or paying personal loans or student loans are working with a lot of individuals who are considered riskier. And so they may have questions regarding their credit score. So let's talk about some of the basics related to that. There are three credit reporting agencies, or CRAs is your acronym if you're looking at this under federal law. Those are Equifax, TransUnion, and Experian, of course. Those companies have their own proprietary methods or products of generating credit scores, and they sell the information in their reports, their respective reports that they have, to creditors, insurers, employers, and other businesses that are using that or that want to use that information to evaluate your applications for various kinds of services. We say obviously employers and employment here, but we know that in New York City and in a couple of weeks, New York State, credit information is not something that can be used in employment decisions. So broader sense across New York State right now, that is still something that is for the next 35 days or so, I believe, potentially still applicable. It is not permitted in New York City and is very soon not going to be permitted in New York State. Your credit file may not reflect everything. Creditors are not required. There's no state law, federal law, gentleman's agreement, or whatever requiring creditors to report information. It costs them money to maintain those files, and so there may be debts that do not appear on your credit report. Which can be surprising to some people, and sometimes that is beneficial, and sometimes that is not beneficial. So as a result, each credit report can look slightly different. So some credit reporting agencies, depending on the kind of credit that you have, certain credit card companies, for example, will focus more on certain companies than other companies. They may have reporting that they do to some of these three agencies and some that they don't. And so if you pull your credit reports from each of the three agencies, which we highly recommend that you do on an annual basis at minimum, they may look slightly different. Some may have more information than others. Some may have more accurate information than others. And generally speaking, the larger an institution is, the more likely it is that it is reporting information. And the smaller an institution is, and especially if they're a third-party creditor, they may not report that information. And so they may also choose to report that information to one bureau or two bureaus and not all three bureaus. And so it's important, which is something that we do when we're talking to people about bankruptcy, to pull all of your credit reports and compare them to make sure that you have all of the accurate information regarding anyone who is potentially making a claim or reporting adverse information or negative information about you, so that you know as much as you possibly can about anyone who is claiming that relationship with you. So Generally speaking, we're not going to go into sort of the five factors in detail that relate to your credit score, but what can negatively or positively, on conversely, impact your credit score is having a high or low utilization of credit. That's going to be based on your monthly statement amounts. And so if you have a credit card with a $5,000 credit line and you have statements that are in the $3,000 to $4,000 range, that's a pretty high level of utilization. And one way that you can lower that utilization is by paying your credit card balance not when it is due, but before the statement date on that credit card. And then the statement amount that is reported to the credit reporting agency, whichever agency it may be, is going to be lower, even though you were using more credit, because they're going to use the amount that is on the statement that is being reported by that creditor, by that credit card company, be it Chase or Citibank or Amex or whatever, rather than information that they may have gathered during the course of the month about the credit that you were using because you went to a restaurant or you went shopping or you paid for vacation bills or whatever. Obviously, not paying bills on time, as defined by the creditor, is going to adversely affect your credit score. Paying your bills on time, whether that's by the statement deadline, if you're a little bit late, but you're not 60 days late and you're 1 to 30 days late, that's different than being 90 days late, being later than that, and so on. Obviously, if there's any sort of litigation regarding creditors, that is negative information. And the largest, of course, which everyone knows, is filing for bankruptcy. I will say, again, we are talking often with a lot of people who have arrears of some kind already. And so lots of people think of bankruptcy as basically, a sort of nuclear option with regard to your credit score. But a lot of the times, if people pull their credit reports and they see the amount of negative information that they may have, that a lot of people have, unfortunately, because of the times that we're living in now, and they get their credit score or even an estimated credit score from one of the agencies that does sort of a pseudo FICO score. It's already going to be, unfortunately, a little bit lower than what they would want. And so filing for bankruptcy isn't going to mean that there's going to be necessarily a 200-point hit or a 300-point hit to someone's credit score because they're already in that position. And sometimes talking with people about that, if you're ever talking with someone about bankruptcy, it may be worth getting that information just so they realize that it's not going to have the impact that they might think it has on their credit score because of the situation that they're already in. As we were saying, maxing out credit cards or not having a long enough credit history, those can obviously affect your credit score. The mix of credit is also relevant. So you can have things like loans, student loans, personal loans, auto loans. You can have credit cards, obviously. You can have different types of credit products, and having a credit mix is also relevant to your credit score. And the length of the account in the fourth bullet is also relevant. So if you have credit cards or someone you're talking to has credit cards, opening and closing lots of credit cards will have an effect, but also closing your older credit cards will have an effect because that will change the average length of your credit accounts. And that's generally the metric that these three companies are using in building a personalized credit score for someone. So if you have your older cards, that are 8, 9, 10 years old, and a lot of your other accounts are 2, 3, 4 years old, and you close that older accounts, it could significantly change the average length of time that your credit accounts have been open and change your credit score as a result. And so depending on the other circumstances that are at issue there, it may be worth keeping those cards open because it boosts your credit score and that gets you to other places that you want to go. As I said, requesting credit reports, one per credit reporting agency per year is free, and we recommend that you do that. Everyone does that to make sure that there is not adverse information that is reported there that is wrong in one way or another because it isn't related to you. There was a period in time where someone had a mortgage, although I have a pretty uncommon name. There was a mortgage for a property, even though I was in my early 20s and wouldn't have been buying any property in California that was somehow associated with me. And the way that I figured that out is because there was a line in my credit report from Experian. It wasn't actually negative. I was just like, what is this? This is not mine, right? And so I wrote to them and I fixed it. And the only way that I figured that out is because I pulled that report. And so it's important, I think, for everyone to get those reports and to check them on an annual basis so that they can figure that out. I'm sorry, I went back. There we go. The ways to request your credit report are at the bottom of the slides. Generally, doing it online is a great way to do it rather than filling out a paper form and requesting it through the mail, because that's going to be information that's going to be sent in hard copy form through the mail, which I think is not something that is the world's greatest idea in this day and age. And you can do that online, obviously, immediately at all times of the day. You'll have to do an identity verification, of course, and that's going to relate to information on your credit report. And so if you, like me, have information that is not known to you otherwise, they're going to be like, do you own property in Orange County, California? And I'll be like, no. And they'll be like, no, you're wrong. You do. So we can't verify your identity. And then you have to figure out what the heck is going on there. So I had some issues with identity verifications. They're like, you own property. No, I don't. I'm 24. Anyway, you should request your credit reports. That's the way you can do so. I think it's a great idea to, obviously, for individuals that we are speaking to who have had disputes regarding payment with various types of alleged creditors, landlords, third-party creditors, student loan issuers, credit card companies, whatever, a good idea to request those credit reports, because there may be information that's being reported that's negative that is not accurate. A credit report request form that is paper looks like this. Again, it has your social security number on there. I'm personally not a huge fan of sending something like that through the mail, but someone could do so, obviously, if they want to do so. There are lots of scams, unfortunately, that relate to your credit reports. Generally, what we see are people who are offering services for credit score rehabilitation or credit cleanup or things like that. Those are generally, in our experience, bogus and a waste of people's money. And you can report negative information and ask the credit reporting agency to fix it. Credit reporting agencies keep negative information for up to 7 years and bankruptcy information for up to 10 years. If there is negative information that's accurate, then the passage of time is what is going to only permit that to fall off. I missed a couple of payments also in my 20s, and they were accurate. It's for my Amazon credit card that I've had for, at this point, close to 20 years. And it was 30 days late, and it wasn't a big deal, but it was a little blip, and it put my credit score down a little bit. And it was accurate. It was true. I had missed the payment. And so it was only after a few years that dropped off. And it actually did, although it was only a couple of points, change my credit score for the better. But if you see errors on your credit reports, then you can dispute that. That is something where it may make sense to do that in a hard copy form. On paper, send it into the credit reporting agencies, send it with possibly some sort of delivery confirmation, and dispute specifically what the issue is. If there are documents that relate to that dispute, such as you settled a case in court and you have paid in full and that case was discontinued based on payment in full, then send that discontinuance that has been affected by the plaintiff, which is required under the state civil procedure rules. You can also, of course, do it online, but a lot of people, especially a lot of older Brooklynites that we speak with, want to do that on paper. I think that is totally fine, as long as you ideally have some sort of mail tracking, so that if there is not a response to that dispute in the statutory timeframe, that you can follow up and you have proof that you sent something in. Again, websites, companies that offer credit monitoring, credit repair, credit cleanup, things like that, generally are selling you things that are free or are taking money without giving you the help that you might need. We don't recommend those. We, would tell people that they can go to any number of entities that can help them with these sorts of things, like pulling credit reports. There's no need to pay somebody to do that. A lot of them are subscription-based services that will end up charging you, $14.95 a month and make it extremely difficult to cancel. We've all been through that. And so those are things that we really just do not recommend. If you want to dispute an item in your credit report, there are lots of templates online that are pretty good. This is the New York City Consumer Financial Justice Project, excuse me, template for this. You can find this online with a little bit of basic internet searching, but there are a lot of other templates that are pretty good. There is no, aside from saying I am disputing the following correct information in my report and I request that you fix it, and then provide that information. Nothing magic that has to happen there. So there's nothing in terms of making sure that you have things in a certain format or even necessarily providing documents, although that's generally obviously recommended that one has to provide to do a dispute. So it's not a legal process. Although there are legal guidelines that apply to it. So anyone who has a dispute that they want to initiate, they can write a business letter and dispute that information. The clearer it is, the more documentation you have, obviously, the more likely it is that you'll get the result that you want. But again, there's nothing magic about it, So you don't need a lawyer to do that. You don't need necessarily any third party to help you. But obviously, people like us who deal with these issues relatively regularly can be helpful in this. And so this is one template that one can use to do one of those disputes. These are some tips for disputing your credit report. You want to have obviously your contact information. You want to be clearly stating that you're writing to someone for a specific purpose, i.e. that you want something removed. You could attach a copy of their credit report and annotate that with the item that you are disputing. You would say why it's inaccurate, obviously, and provide your supporting documentation and ideally proof of mailing. All right. The legal requirement is that the CRA, credit reporting agency, must respond within 30 days in writing with the results of the investigation. If they're denying your request to remove or change information, they have to say why. And if they have updated your credit report, then they have to provide that new credit report. And they also are obligated to notify the two other CRAs of any information that they change so that you don't have to go to, obviously, all three agencies and write the same letter 3 times to get the same result. And so you can follow up with those agencies if you haven't already, for example, requested your report that is free for the year. Once you get a correction from TransUnion, you can go to Equifax and Experian and get your reports and make sure that they have followed the information from TransUnion in adjusting that information. All right. I know that was fast, but we have lots of other things that we can talk about. And so I'd like to move on to those things. And seeing no Q&As, rather queues, my apologies. Seeing no queues at the moment, I think we can move on to debt collection. So debt collection is potentially very simple and can potentially get very complicated. In general, there are a few steps that happen in the life of a debt. If you stop paying a creditor, then again, depending on how much money the creditor is spending on providing all of this information and the size, generally speaking, of the institution, then they will report any delinquent payments to a CRA or one or multiple CRAs. They will, generally speaking, engage third parties, debt collectors, to try to collect on a debt. The larger financial institutions, particularly agencies or companies rather that issue credit, will send letters on their own. So Chase will send letters on their own offering compromises to resolve outstanding payments that they think exist. Bank of America will do that. American Express will do that. They'll send their own letters. Some other companies will engage third parties immediately to start collecting. So a lot of utilities will do that. They won't make calls themselves. They'll have third parties do that. Debt buyers third-party purchasers of debt will do that. And so people may get calls from agencies or companies that they've never heard of asking about certain debts. A lot of people take that to mean that the debt has been sold to that party, but often those are, especially early on, collection agencies, not companies stating that they have purchased the debt. Generally, after 6 months, a debt is charged off as bad debt. Again, a lot of people we speak with think that that means that the debt is no longer collectible or is no longer going to be collected by anyone, whether that company or a third party, in the future. That's not what that means. It is an accounting procedure that is used by creditors. It doesn't mean that you don't owe the money. There is potentially one exception to that, which is if someone receives a 1099 for forgiven debt. If someone receives a 1099 for forgiven debt and they don't do anything with it, they can't go to court because there are cases about this and say, I thought that based on this form that I received, that the debt was charged off and I don't owe any money because they're claiming this as a loss and for accounting purposes. And so that means I don't owe the money. That is not a winning argument. If you filed your taxes and you claimed, because you have to, that forgiven debt as effective income and then paid taxes on that, that is an open question and a reasonably good argument, at least to me, that that should no longer be a debt that is collectible. However, I am sure that because that is not a settled question, at least in the part of New York City that I am working in, the second department, that the plaintiff, whoever it is, wouldn't try to litigate that. But if someone has a 1099 and they say that they filed taxes, that is an issue worth pursuing. In any case, moving on. Step number 4, the creditor may sell the debt to a third party, which we call a debt buyer, or a plaintiff would call a third party creditor. But we refer to them as debt buyers, or they may keep the debt for themselves. And that is just a choice that businesses make. It may change over time. But a lot of larger companies like Chase or Bank of America or American Express will not sell their debts to third parties. They may think there's some sort of prestige issue at play or something like that, but they do not sell debts. And so if somebody came and said they were contacted by, let's say, just to take one firm, Rubin and Rothman, and they say Rubin and Rothman is saying that they purchased a Bank of America debt. Rubin and Rothman is a law firm. They are contacting someone on behalf of Bank of America. They do not own the debt, and you can be sure that that they're not saying that they are the owner of the debt for something like that. However, otherwise, if someone contacted someone and they're, for example, called LVNV Funding, which is a third-party debt buyer that we see all the time, and they say, we have purchased this debt from, let's say, Citibank. That could mean that there is a third-party debt buyer, not just a third-party debt collector who is contacting someone on behalf of the original creditor. There could be a third-party debt buyer who is contacting someone to seek collection directly for that debt that they're claiming that they own, and not just are merely trying to collect on behalf of another party. If that occurs, there is supposed to be a notice of assignment. A notice of assignment simply means a letter, either by the purchaser or the seller of the debt, stating that the debt has been transferred. That can be, again, just a simple business letter saying, we are Citibank, we have sold this debt related to your Macy's account. That debt is being sold to LVNV Funding. Go pay them, go deal with them. We are no longer involved in this. Or LVNV Funding, or a law firm on behalf of LVNV Funding, or a debt collector on behalf of LVNV Funding could be sending those letters. And we'll talk a little bit about what someone does in a slide or two. But all of those situations are potentially possible. You could contact, if you're an advocate, any one of us and say, hey, we were contacted by such and such company. It seems potentially illegitimate or like someone's trying to scam someone, what's going on here. And generally we will have a pretty good sense of, is this, a legitimate debt collection? Is this a law firm or a collection agency on behalf of an original creditor? Is this a third-party debt buyer that we see very regularly? Or is this someone trying to get money like we see with toll scams, for example, when people getting texts claiming that, that someone has a toll debt and they need to pay right away, which is not true. And people don't get debt collections for tolls over the phone, especially by text. Someone who's trying to perpetrate a scam. Otherwise, then, step number 5, the last step, a creditor or a third-party debt buyer will obviously engage in collection activities, and they may or may not sue on the debt, which is obviously where we might come in. So, debt collection protections. Debt collection
Aaron,
protections.
so a question. So if
Yes.
one of the things we may see is that there's a judgment that someone gets from a housing court case and they've left that place, so they may not necessarily know about it, and now they find it about 8 years later on their credit report. At that
Mhm.
point, how would someone know if the debt was sold? Would it say on the credit report or no?
It may or may not say on the credit report, depending on who has furnished the information to that credit reporting agency. We do not tend to see, although it's obviously possible, and you may see more than we do, situations in which a landlord has obtained a money judgment in housing court in some manner and has then sold that to a third party that does not pursue that individual in civil court.
Okay.
Um, we do see, obviously, situations in which, and we'll talk a lot more about this in a little bit, where money judgments or issues of liability, financial liability, have been severed from possessory issues, and a landlord is suing in 2024 related to a landlord-tenant case that was filed in 2017 and decided in 2020, and liability for some of that period was severed and left open. And now they're suing on that. And they may have served someone at an incorrect address and obtained a default judgment, or they may be suing someone now, and that is now in court, and that could be reported to a CRA. The only way that that can be checked in terms of proceedings is by going to the e-court system or the clerk's office. So for Brooklyn, that'd be 141 Livingston Street. The third floor is the civil court. Second floor is the housing part clerk, and checking for any cases in one's name, which can also be done online through e-courts. And if there's, a situation in which this should have been e-filed, then obviously through NYSEF and searching for a client's name. If there was no court proceeding and a landlord provided information to a CRA that money was owed, then I would say that that is something that should be disputed. And I think, generally speaking, although I don't have tons of experience with this, I don't think a CRA would want to wade into disputes related to landlord tenant. And so if you're the tenant and you come in, you say there were issues related to hot water or mold or a rodent infestation and all these other things, and this is not a valid debt and I want it removed, I would assume that they're going to remove it rather than getting involved, because there is liability for credit reporting agencies. That's the Federal Credit Reporting Act. If there is incorrect information up there. And, those sorts of situations are tough situations that are not necessarily going to create liability for those credit reporting agencies, but that's just as background, a reason why a credit reporting agency may remove information like that rather than trying to wade into that dispute. And so I would suggest that that is something that should definitely be dealt with if one has the ability to do so. But generally, we don't see third parties get involved post-judgment related to rent arrears. We do see that sometimes with credit judgments where a bank, an original creditor, obtains a judgment and then they don't collect on that judgment. That judgment's getting older. They don't think they're going to collect anything on it. There's a market for those sorts of debts. It's a very cheap market because most likely no one's going to get any money, but there are sometimes third parties that invest in those and then go seek collection. Generally, it is sold before a lawsuit on both the landlord-tenant side and on the credit, student loan, credit cards, whatever side. And so it'll get sold and then they'll pursue an action after that.
Follow-up question on Nipa's
Yes.
question. Is there, like in housing court, the defense latches a tenant can raise if they believe that the landlord is coming after the money, after a long period of time? Is there a similar defense in the civil part, meaning like the landlord is now coming after a money judgment for a case that happened a really long time ago, and they're now trying to get that money? Is there any sort of like time
Yes.
on
So
that?
yes, and yes. So there's obviously statute of limitations issues. So one of the things that we are dealing with right now um, is the change in state law to statute of limitations that relates to consumer debts and whether that applies to rent arrears cases in civil court. The statute of limitations was changed in 2022, April 2022, from 6 years to 3 years, which is obviously highly beneficial. And so that can obviously be an issue. Whether that, unequivocally applies to rent arrears cases, I would obviously say yes, but I think in fairness, that is not a decided issue at all. Although there's some resources that the court has provided, things like that, that we can follow up on. In terms of latches, absolutely. absolutely. You're going to have to plead with some particularity, exactly what the prejudice is that has resulted from that delay. Obviously, a credit card company suing on, 2 years and 350 days of a credit card debt since the date of last payment or use of the card, that's ridiculous, but they can take up to all that time. And so if you're saying that there is something obviously that has hindered my defense because of that delay, you're going to need to at some point very shortly after providing that answer be specific. Generally there are not motions to strike answers for specificity in civil court, but I guess it's entirely possible. But at some point, probably in conference, the judge or the plaintiff is going to say, what's the issue, right? And you'd have to provide some specificity as to that. But otherwise, yeah, absolutely, latches is absolutely a defense, and that could relate to obviously non-rental arrears as well. If there are issues like student loans that have a really long repayment period, um, or other things for which there may be a witness that a defendant has that can no longer is no longer available because of the delay in prosecuting the action, or documents that somehow were lost or destroyed that are no longer available because of that action, you can certainly raise those. All right, so federal debt collection protections, generally speaking, they apply to not original creditors, but those who are collecting debts of another, meaning third parties that have purchased debts, or anyone acting on behalf of that third party debt buyer or an original creditor. It does not apply to the original collectors themselves. So everyone has heard, this is an attempt to collect a debt. Any information obtained may be used for that purpose, right? That is FDCPA language, Federal Debt Collection Practices Act language that states to consumers the rights that they have regarding third-party collectors. So debt collectors under federal law are prohibited from engaging in deceptive or unfair tactics to collect on a debt, using false or misleading statements, and harassing debtors. We'll talk a little bit about what that means specifically in New York City in a second. I just want to point out right now that there is a state law analog to deceptive and unfair practices in New York. It does not work very well. It is not a very strong law. And so it is not something frequently that one can rely on to try to claim that there are some unsavory tactics that are being employed, and that should be a defense to any sort of collection action for that debt. Hopefully that is something that changes soon, but for now, it is not a great set of statutes in New York, and not something that you want to rely on except for some extreme circumstances. So, as I mentioned, New York City has extra protections for consumers. No more than twice a week, not before 8 or after 9. Everybody has to be licensed through Consumer Affairs. And a landlord tenant does not have to be licensed, but any debt collector has to be licensed. And so if you see a consumer credit complaint, there will be a DCA number either on the first page or in the complaint itself. They're not doing that obviously for fun. They're doing that because they have to be licensed. And in a consumer credit case, you have to disclose your license number in the complaint itself or on the summons. And a creditor must disclose if the debt cannot be collected on, i.e., it is past the statute of limitations. We don't generally see creditors file suits, although they could engage in other collection actions because it doesn't cost very much to send a letter, obviously. But we don't see creditors generally come into court and say, I guess for obvious reasons, this is a debt that is past the statute of limitations. So that's not something that occurs in court. People don't come to us with those letters. Those letters, I'm sure, could be out there. Because there are lots of unsavory tactics that go on even in New York. But that's not something that would, generally speaking, come into court. We see what we were just talking about before, which is you're at the very end of statutes of limitation, and a landlord or a third-party debt buyer in particular is bringing a lawsuit to get in under the statute of limitations, even though it's been years and years and years, and the person has thought that they are able to move on completely for that debt, and they're bringing it at the last minute to avoid that statute of limitations issue. If a consumer is receiving phone calls or letters regarding a debt, they should send a debt verification letter. And we'll go into shortly what that means. So if you ask for debt verification, creditor, most importantly, cannot continue to collect on the debt. Generally speaking, we're not talking about court, obviously, so we're not talking about continuing proceedings. We're talking about people contacting you or possibly harassing you, trying to get money from you outside of court, they cannot continue to collect on the debt, which includes filing a lawsuit, but obviously includes contacting you further by mail or by phone or by text or by email until they have sent verification. That being said, there is no deadline for them to send verification. And so sometimes it's annoying because you send a debt verification letter, you don't hear back from that creditor for 60 days, 90 days, 120 days. You may think, okay, they've stopped collecting. And then eventually you get debt verification and the process starts up all over again. That's because there is no deadline. And so there is no way that you can say, okay, it's been 45 days or 60 days since you received this, and I sent this by certified mail, so I have tracking, and you have not responded to me, and therefore debt not valid. And so you can't do anything any further. They can send that verification, generally speaking, whenever they want. They just can't contact you until then. So a debt verification letter can also include request to cease communication. So if you're receiving phone calls or letters regarding a debt, then you can send a letter to the creditor saying, do not contact me further. And they cannot contact you further. They can bring legal proceedings, obviously, but they cannot contact you further regarding that debt, aside from just confirming that they will be ceasing communication. I think it sort of goes without saying, but don't provide any personal sensitive information to any debt collector over the phone or in writing when saying, do not contact me any further. They don't need that information. They just need your name and your address and to cease contact with you. They obviously have your phone number or they wouldn't be contacting you in the first place. Ditto your email address or any other means of communication. And so if you have done that, then they can contact you one more time to say that they are ceasing communication, but otherwise they are not allowed to contact you further. They can choose to file a lawsuit if they want to do so. Because of the Federal Debt Collection Practices Act protections and the liability for debt collectors if those are violated, it is always a good idea to keep records of your interactions with those debt collectors. Who called you? When they called you? Did you receive a letter? When did you receive the letter? Keeping the envelope can sometimes be extremely beneficial for finding out, for example, when you became aware of a debt. If that debt is not a valid debt, that will start your statute of limitations for bringing a suit under the FDCPA. So you want to keep records of all of those interactions as detailed as you can, so that if you need them in the future, you have them to show how many times a collector, for example, has been on notice that you have asked for communication to be ceased or that you have disputed the veracity of the debt and they need to send verification, et cetera, et cetera, et cetera. So this is an example of a debt verification and cease contact letter. As you can see, it is very simple. It is basically 7 lines long. It is, dear sirs, right, or to whom it may concern or whatever, I want you to verify this debt under the federal statute that requires it. Please send that information to this address. Your company has contacted me, and in accordance with the FDCPA, I am sending you notice to stop contacting me, and thank you for your time and attention. Sincerely yours, consumer. That's really it. There are, again, lots of templates here. You do not need to invoke the statute. Generally speaking, it is a good idea to make sure that there is no dispute as to what you're saying, and so it's helpful to invoke the statute, but it's not required for that to be an effective debt verification letter. You are really only needing to say, I'm asking you to verify the debt. I dispute the debt. Please verify the debt. That's really as much as you need to say. Stop contacting me. Cease contacting me. Except as prescribed by law. You can put in if you want to, but you don't have to. That's really that simple. And so again, this is, invoking legal protections, but is not a court proceeding. This is something that you can find templates for on your own. You do not need a lawyer to draft a specific debt verification and cease contact letter. Anyone can send these. So advocates can definitely do this, and consumers themselves can do it on their own so that they can get this relief and get the information that might be helpful to figure out what's going on here and what they might need to pursue after, such as a police report for identity theft or what have you. You'll see at the bottom there's a CC to the Federal Trade Commission for the Northeast region. Obviously, under the current administration, we are not expecting that the FTC and any of its associated agencies are going to be all that helpful in dealing with disputes, but sometimes it doesn't necessarily hurt to forward that information to those entities. Again, I just wouldn't at this point expect a whole lot of help from the government with any of these things. So, legal processes. We're going to start transitioning now and talking about legal processes. We're about 45 minutes in or so, and so we'll spend basically the rest of our time talking as much as we can about legal processes. So getting sued on a debt, whatever kind of debt it is, right? If you receive a summons and complaint, which are the papers that are in civil court cases, this is not, again, for us, landlord-tenant cases, so we're not talking about a notice of petition and petition, we're talking about a summons and a complaint. If you receive court documents, then you need to respond. If you do not respond, then you are in default and a creditor can apply for a default judgment. Even if you did not receive service of process properly, the court, generally speaking, is not going to be going through affidavits of service with a fine-tooth comb. If there is an affidavit of service, if it is facially complete and they submit the necessary information that they need to get a default judgment, especially in civil court, although I'd really say in civil and Supreme Court, they're going to get a default judgment. And then you're going to have to file an order to show cause to try to vacate that default judgment and make the arguments at that point about whether you've been properly served or not. You can deal with that on the front end rather than having a default judgment and collection actions initiated. If you receive court documents, then you should respond to those. Of course, it is ideal if before you respond to those, you talk to someone who is knowledgeable about those kinds of collection actions to figure out what kind of defenses that you might have. And we'll talk about lots of different reasons why that may be true. It may not be necessarily the case that what you want to do as a defendant in this case is rush in and file an answer right away, because that may take away defenses, basically is what I'm saying, that you might have by doing that answer. There are court programs,
Quick
obviously.
question, Aaron.
Yes.
I might have missed it, but is there a time limit on answering?
There is, and we can talk all about that.
Okay.
We can talk all about that. We will talk all about that in service of process. What I would say now, generally speaking, in civil court, if someone came to you or came to me and they said, I received these papers, they were given to my spouse at my home 7 months ago, and that person gave them to me, but we were dealing with a family issue at the time, or I was sick and I forgot, my advice would be to go into court and answer. And let the other side send a notice of rejection of that answer, and then you can deal with that at that point. Because basically the procedural rules say if someone sends a paper untimely, the other side has to formally reject it. That is a notice of rejection. If a notice of rejection is not sent, then their right to reject has been waived. And so then your answer is in. If someone has a service of process defense, again, that may not necessarily be what they want to do. It's been a long time since a case was filed. That may not necessarily be what they want to do. But especially in civil court, at least at the moment, while everything is getting transitioned to e-filing, what you can do is answer and then see if they reject it. And if they do reject it, which doesn't happen very often, but may happen more frequently in the future and does happen on occasion now, then you can deal with that.
Just to it's a kind of basic question, but if you could just briefly, for anybody who doesn't explain what e-filing is, and then also, is there a specific type of civil court where the judgment can be enforced, since we have different ones?
Could you, I'm sorry, Nipa, could you say the second part again?
Is there a specific type of let's say someone gets a debt in housing court, is there a specific court they would have to go to get the money judgment enforced, or they can, is there what would the procedure to be?
Is there a specific court that the creditor would go to seek further enforcement of the judgment?
Is it supreme
okay.
or small?
So, so electronic filing or e-filing is something that is increasingly being introduced as mandatory for non-pro se litigants in courts across the state. So as of August, if I have that right, for example, there is mandatory e-filing for plaintiffs in consumer credit cases in civil court. And so it used to be up until August of last year that if Bank of America wanted to sue you, then they had to bring in papers in hard copy form to the clerk like it was 1947 or whatever and start a case in person like that. Now there is electronic filing, and almost all of these things can be done electronically and instantaneously through that electronic filing system. So the electronic filing system for New York is called NYCEF, NYSCEF, New York State Courts Electronic Filing. There's a website for that. If you just hit NYCEF into a search engine, you will come to that website. A pro se person or an attorney can sign up for a NYCEF account. You can opt into as a pro se NYCEF filing if you want to. There are certain benefits that exist with that. Namely, generally speaking, filing a document is service and filing instantaneously. So if you were filing, for example, a motion to dismiss against a landlord, and you are pro se, you sign up for e-filing, you get yourself an e-filing account, which is not as easy as it sounds, but let's just say you do. And you have your motion papers together, you upload those documents as PDFs to the NYCEF website. You pay a filing fee if you need to pay a filing fee, depending on what court you're in. You hit file, and boom, those are served and filed, subject to the clerk's review, obviously, right? Whereas right now, if we're helping people and a case is on paper, or the pro se needs to proceed on paper, then we're talking about printing out all those documents, executing those documents, making copies of those documents, talking to people about what an affirmation of service is, who can serve those papers, how they serve those papers. They need to make copies of the affirmation of service, et cetera, et cetera, et cetera. It is often very confusing for people. So to some degree, there is a certain benefit, but obviously for lots of the people that we work with, it is very difficult to navigate that system because it's not something that they're doing on a regular basis, the same way it might be difficult for me to teach seventh graders about math because I may know that math sort of in the back of my mind, but I don't teach people math. I don't teach people math on a regular basis. If I had to walk in and start teaching seventh graders math, I probably would do a very, very poor job of it. And so, we obviously take a little bit for granted as attorneys about navigating the NYCEF system, but it is useful in a lot of ways for everyone. To do that. And you can, obviously, for people who are coming in who don't know a lot about their case, if you have an electronically filed case, it is, of course, way easier to get documents because the documents are numbered, they are in readable format, or they're in legible format, I should say. They can be converted to OCR, and you can find them instantaneously at any point. Whereas, if you have to go in and get a housing file from 2011 or a Supreme Court case from 2013 that was never converted to electronic filing, you have to physically go down, or someone has to go down to the clerk's office. You have to make a request. It has to be hauled out of storage. You open it up. God knows what you're going to find. May not have the papers that you need, may not have a ton of papers at all in there, and you're left trying to figure out what to do at that point. So on NYCEF, you will have all of that information there nicely and easily. Often we are talking to people and saying, for example, we need to see the affidavit of service. You're claiming that you have not been served properly, or we think you may not have been served properly. We want to see the affidavit of service. Right now, they have to go down to the clerk and get the affidavit of service. Shockingly, which I mean sarcastically, probably to all of you, if you go down to the clerk and ask for an affidavit of service, on a vast majority of cases, they're not going to have it. Maybe it was filed, maybe it was not filed, but it doesn't really matter because they're not going to have it. So what does someone have to do? They have to contact the law firm representing Bank of America or Chase or Capital One or whoever it is and ask them for a copy of the affidavit of service. Their chance of getting that before the next court date, honestly, pretty low. Generally speaking, someone's going to have to wait and make a request in court for that affidavit of service that gets transmitted back to the office of the law firm representing that creditor, and then it will get sent to them. And that could be 3 or 4 months to get that document. While we're sitting around waiting, figuring out whether someone has a good personal jurisdiction argument or not and should be potentially making a motion to dismiss a case. That is ridiculous, right? But, that is the way that it often has worked for the last however many years, decades. NYCEF is going to potentially get rid of that, for better in terms of dealing with those issues, for worse in terms of creditors moving quickly for default judgments. Anyway, that is the NYCEF system. In terms of collections on a judgment, we're going to go through the Exempt Income Protection Act, EIPA, EIPA, CPLR 5222 in a little bit of detail at the end. So if we don't mind, I'm going to push that for another 20 minutes or so, and we'll talk about all of that. But the short answer is, once there is a judgment, aside from renewing a judgment, after 10 years, there is nothing else that needs to be done in court to enforce that judgment. There is a notice of restraint. There are information subpoenas that can be sent to private entities for information about judgment debtors. And then there are notices of restraint or notices of garnishment that go either through the bank or through the marshal's office in the case of an asset or an income. And those get enforced through those mechanisms or through those entities. And there's nothing in court that needs to happen. If there's nothing in court that needs to happen. And so they can go on from there. Anyway, so basics of the debt. So there are court programs, obviously, that help people who do not have attorneys with getting information and advice about what to do. Of course, in housing court, there's the help desk. The help desk is extremely busy, very hard to get information and representation from the help desk, given how many cases there are. There is our program, the Volunteer Lawyer for a Day program, which helps people in court, and Claro, which helps people outside of court with getting advice or information or help with answers or help with responding to discovery or help with motions, whatever the case may be, in each of the boroughs in New York City. They are extremely burdened. It is still very hard to get that information, but there are court programs that give people access to those information. Creditors cannot take money that they think you owe them unless they get a judgment. So that's the main thing. A lot of people come in and say, I have, money restrained on my bank account, but I never had a court case. That is, in New York, at least, if there's a New York judgment, not going to be true. You're going to have a judgment against you. You don't necessarily know about that judgment. You may have a great argument for vacating that judgment and dismissing the case and never owing that creditor a penny, but there will have been a court proceeding of some kind that you, again, may not have been aware of, and there was a judgment that has been obtained. And of course, the important point of that for talking with individuals is if there is a judgment that has been entered, you still have your rights. You can go into court to vacate that judgment and deal with the case. You don't just have to say, there's a judgment, I'm at their mercy, they can take money from my employment, they can take assets from my bank account or other property, or they can do whatever they want, and there's nothing that I unfortunately can do about it. You, of course, have rights, depending on what happened in that case, to deal with that and come up with a more favorable result. So let's talk about EIPA. So EIPA, the Exempt Income Protection Act. So as of 18 years ago, EIPA is in place in New York, and it changed very substantially the process that judgment creditors have to go through to get income and assets from individuals that are primarily in the form of bank account funds. So if a creditor has a judgment, then they can take money through an income execution that goes to your employer, and payment is done through the marshal's office, or they can get an asset levy, which primarily we're talking about bank account levies. The state law that protects those funds, part of those funds from creditors, depending on the source of the funds and the amount of the funds, is EIPA. So when we say EIPA, we're talking about state law, state procedural law, CPLR 5222A, that protects judgment debtors, which is what people in this situation are legally, from certain kinds of collection action. So creditors cannot take specific types of income. Those people are what we would refer to as collection proof. They are not judgment proof. A creditor like Bank of America can and will still get a judgment against them, but they cannot actually potentially take any of the money. That would be protection under federal and or state law. So things like SSI, supplemental security income, SSDI, food stamps or SNAP, PA, veterans benefits, spousal maintenance and child support, and pensions and retirement accounts like 401ks, 403bs, IRAs. Those are protected income and assets. And so if someone has a bank account and they get $1,100.32 in SSDI or Social Security retirement funds every month, and that is the only income in their bank account, can that money be taken? No. Can a judgment creditor, intercept that Social Security and take a portion of it every month to satisfy a judgment? No, they can't do that. Period. End of discussion. If that happens, that's obviously a big no-no and a basis for a lawsuit. So that money cannot be taken at all. And so often what we do in those circumstances is we make an application to a creditor, whether it's a judgment creditor or in court through someone who wants to be a judgment creditor for discontinuance, voluntary discontinuance based on that source of income. We do this in civil cases with rent arrears. It is less successful than it is for larger financial institutions or debt buyers who do not want to go through the pain and expense of dealing with this. And so they are generally much more willing than former landlords are to release someone from a case and from paying at all in the future from any sort of legal liability on the basis of this exempt income. So what will happen in these situations if someone has, I mentioned LVNV funding before, LVNV funding sues someone or another debt buyer like Midland Credit Management sues someone, and we talk to them at Claro and they say, listen, I am 73 years old, I get Social Security, I get $1,200 a month, and that's what I get, and that's it. Then we will take a copy of their benefit letter, we will do an affirmation of their budget, and that they don't have otherwise assets sitting in a bank account somewhere to pay that debt. And we will send that to the attorneys for the plaintiff and say, please discontinue. This is not a legal argument, obviously, I guess. Obviously, this is not a legal argument. They can get a judgment if they want to. Again, there's a difference between being collection proof and being judgment proof. If they want to get a judgment, they can get a judgment. They can't collect on that money, but they can get a judgment. But we obviously, for the people that we're trying to help, or for the people that you are trying to help, want people to avoid that judgment in the first place if it's possible, because obviously circumstances can change over time. A judgment is valid for 20 years. And so if in 2037 they win a scratcher or are in an unfortunate car accident and have a personal injury claim, or a long lost relative passes away and it turns out they've inherited $15,000, then all of a sudden they have collectible assets that someone can take because they got a judgment in 2026, even though it's 2037, because the statute of limitations on a judgment is 20 years. And if you get any sort of money, it resets to another 20 years again. So we'd prefer that they don't have the judgment in the first place. And the way that we would do that is we would ask the plaintiff to voluntarily discontinue based on this source of funds. And we'd provide proof of that source of funds. Again, for rental arrears cases, much less successful. They will, like some of the original creditors, probably most likely try to get a judgment and then see if they can collect in the future. And maybe they can't, and maybe they never end up getting anything, but they're not going to discontinue in court for that same reason. Anyway, back to EPA. So EPA is very, very specific in the protections it provides and it doesn't provide. So going through EPA in detail, I think, is really beyond the scope of this kind of conversation, but let's go through some of the basics. So if you have a bank levy, and these numbers are not correct, there are two amounts that a creditor cannot take and that a financial institution where someone we're talking to has funds cannot restrain if the money is at or below this amount. So as of January 2026, this gets reset every year by state law. That amount for non-governmental benefits, meaning an account that doesn't have governmental benefits, is $4,080. If there are government benefits as part or all of the source of funds, that amount is $3,425. So in other words, if someone has a judgment against them through Capital One, and it is for $3,500, and Capital One sends an information subpoena to Citibank and says, do you have an account with Joe Smith? These are the last four of his social. This is his address. We have a judgment against him. Attached is a certified copy of the judgment. And the bank says, yeah, we do. And he has an account, and that account has $2,300 in it. Can that bank restrain that money? No, they cannot. Even if they made the mistake of restraining or freezing that amount of money, can Joe Smith walk into that bank and get all of his money immediately right away, or otherwise the bank is violating EPA? Yes, absolutely. 100% he can. And for $2,300, it doesn't matter the source of the funds in the account because it's less than the statutory amount for accounts that don't have government funds and that do have government funds. We do see on occasion banks just freeze accounts, and they will freeze them if there are $3,500 and the judgment is for $2,300. I think I reversed the numbers for my example. And so if the judgment is $2,300, what they'll do is they'll freeze double the amount to ensure that they have frozen enough money to satisfy the judgment creditor, and someone will wake up and see that they had $3,500 in their account and there's a freeze for $4,600 and they have negative $1,100 in their bank account. And they will think that all of that money is gone. That is not really what has happened. What has happened is the bank has frozen double the amount and adjusted the account balance on account of this judgment. And that action would be violative of EPA, but let's leave that part aside for right now. And that's what they'll see, and they'll think that that money is gone. And that is not really true. And that is a limitation of EPA, because the rights that people have are supposed to be set forth in what's called an exemption form. And lots of people do not get those exemption forms. So they just walk into their bank or pull up their account information on their phone or a computer one day and see a negative balance and think all of their money is gone and they owe someone $1,100 on top of that, when that's really not what happened. But in terms of the statutory amounts, that's the amount. Before that happens, there are two things that are supposed to occur. A bank has to send you an exemption form. They get that exemption claim form from the judgment creditor. So the judgment creditor, when they get a positive result to an information subpoena, is supposed to then say, okay, we want that money. Here's the claim exemption forms. And the bank is supposed to relatively immediately send those forms on to the judgment debtor, meaning the person that we are speaking with. Very, very frequently, those forms are not received, and so there's no information that's sent. But that is what the requirement is. On top of that, the judgment creditor themselves is supposed to send a notice, at least within the last year, of restraint. And so, in theory, a consumer is supposed to receive two notices, one from the judgment creditor directly, which generally means the law firm that is taking action on behalf of a plaintiff in our sorts of situations, but it could be a third-party debt collector, I suppose, or the original creditor themselves. And from the bank, they're supposed to receive letters that there is going to be collection action enforcing a judgment. And often people do not receive those. But if they do, or you talk to them and they say they haven't received them, then they should get them right away. And if they have an exemption, then they should respond right away. The statutory standard is 20 days from the postmark on the letter from the bank with the claim exemption forms. So that is a very, very short period of time, because obviously that encompasses the mailing from the bank to the consumer in the first place. Lots of people have issues with USPS. Lots of people have issues with mail and their neighbors, especially in larger apartment buildings. They may receive that on day 8 or day 12 of day 20. They don't have 20 days from the date that they actually received it. They have 20 days from the date of the postmark, meaning when the bank put it in the mail, or at least the date of the postmark. Maybe not necessarily when it actually got in the mail, but that is their deadline. So that is a very short period of time. If they have received it, then they should fill it out right away if they have one of these sources of funds that is exempt, SSI, SSDI, et cetera, et cetera, et cetera. If they receive it and it is outside of that period, they should still send in that form to the bank. And it is a very good idea in both instances to make a copy of that form for your own records, and to make a copy of that form and to send it to the entity that is representing the judgment creditor, which generally, again, means a law firm in our situations. Send it to the law firm saying, hey, this money is exempt. And partially what you're saying is, you law firm, even if the bank sends you this money, you better send it right back, because it is not money that you are supposed to have, regardless of whether or not I have made a claim within 20 days, and so have a statutory right under EPA to not have that money removed from my account at all. Then they should be returning that money. And generally they will, because they would have EPA liability, potentially, depending on what happens thereafter. And so they don't want to deal with that. And so they will send that money back, even if it is not within the EPA guidelines. Otherwise, again, if it is outside of the $20, contact your bank and explain that the funds are exempt. What the bank is supposed to be doing, what EPA requires, is that the bank goes through its own analysis of the deposits into the account and is supposed to verify whether deposits are for money, deposits are of money that is exempt. Because obviously, right, when we have our bank statements, if you're getting Social Security, if you're getting veterans benefits, if you're getting pension benefits, those are marked as such in the information in the deposits. Of course, the bank can see that. And so the bank, before they go freezing money and sending it around to marshals or to law firms or to wherever, are supposed to be looking and seeing what is exempt and not including that in potential money that is A, frozen, and B, eventually sent to the judgment creditor or their agents. We do see a lot of problems with this. It is an extremely good idea if you encounter one of these situations to be very, very, very proactive in talking to the bank or helping a consumer talk to the bank and the law firm or other entity that is representing the plaintiff, the judgment creditor, to explain these situations. If things do not get resolved the way that they ought to be resolved based on the ultimate exemption of the funds, the solution is to go to court, to civil court or the court where the judgment was issued, and to file an order to show cause to demand return of the funds, which sounds a little bit ridiculous because there is no private lawsuit under EPA, meaning, in other words, if a bank or the creditor has violated EPA, you can't sue them for a violation of EPA. So it's strange that you would have to go to court and then say, these guys took my money, i.e., they basically violated EPA, and I should be able to get that money back when the Court of Appeals for New York has said that there is no private right of action, private lawsuit right under EPA. But that is what your solution would be. You'd go to court and say, most likely, A, I want this judgment vacated and the case dismissed because there was improper service. And the first time I'm hearing about this is a notice of restraint or a notice of garnishment for my bank account for my employer. But B, they took a bunch of money that they were not allowed to take, and I want them to give it back. All right. Does anyone have any questions? I'll pause for 1 second. I know it's 3:15 and we don't have too much more time. Does anyone have any questions about anything related to EPA? EPA is a little bit complicated. It's a good idea to talk to a more experienced advocate if you are dealing with these issues. Otherwise, EPA enforcement is supposed to run through state because it's a state law. So you'd be talking about the Department of Financial Services, which regulates the financial institutions, i.e. banks in New York State, or you'd be talking about, obviously, the State Attorney General's office. However, getting relief from those agencies is not going to be the fastest, I think is obvious. And so again, your best solution most likely is going to court and filing an order to show cause. All right, let's move on. So let's start talking a little bit more about some of the procedural and substantive issues related to rent arrears cases. A lot of these things are going to be things that probably people on this call know better than I do because they are housing court defenses. As Adriana was talking about before, a little bit earlier in this call, any defense that one has in housing court can be asserted for a rent arrears case. If you have implied warranty of habitability issues, can you assert those in your civil case for rent arrears, even though you are no longer in possession of the premises and everything does not have to be routed through housing court? Absolutely. Can you raise constructive eviction defenses? Absolutely. Can you raise defenses or counterclaims related to a security deposit? Absolutely. If you are a senior and you moved into senior housing, can you use that as a potential defense to breaking your lease early and incurring lease obligations? Absolutely. Can you raise a defense that the landlord failed to reasonably try to relet the premises, which is obviously a requirement that we now have in the last couple of years in New York State for these leases? Absolutely. You can raise all of those defenses. And so most of the time, those defenses get litigated in housing court. They don't get litigated, quite honestly, in civil court. And so a lot of where that substantive knowledge comes from is housing court and housing court decisions and not civil court decisions. But in any case, let's talk about it. Broken lease cases are obviously post-possessory, meaning that if someone is in the apartment, everything is supposed to go through housing court. This may be a little bit too much information, but there are some judges who don't totally understand that. And there are some plaintiff's attorneys who every so often will try to bring repair or damage proceedings, I should say, in civil court or Supreme Court, even though the tenant is in housing court and is in possession of the premises, may or may not be in housing court. Obviously, at least to me, right? If you had a tenant and you were trying to get rid of a tenant, a great strategy to circumvent the protections of housing court would be to sue your tenant for $25,000 or $50,000 in damages in civil court or Supreme Court and say, hey, I will settle with you. What I will do is waive these damages if you agree to what? Vacate the premises. That would be circumventing the jurisdiction of housing court. That is not permitted. That may be a situation that you find someone in or someone comes to you and they're facing, and you need to help them advocate around that. Generally speaking, though, these should be post-possessory. The tenant is no longer in possession of the premises, or the occupant is no longer in possession of the premises, and we are talking just about money. So these are actions brought by landlords for alleged rent arrears, attorney's fees, tenancy-related charges, damages, repairs, et cetera, et cetera, et cetera, that a landlord can bring. They will file those in civil court. Now jurisdiction is up to $50,000, or in Supreme Court if it's more than that, in basically two circumstances. If there is a money judgment that existed in housing court, and they're trying to then enforce that, or the tenants vacate and their rent arrears and they no longer have an issue of possession, but they're claiming that there is money that is owed. Obviously, as you all know, tenants are often compelled to break their leases because of various types of issues. And there can be lots of disputes as to the conversations that occurred between management companies or agents of the landlord and the tenants about what is happening when a tenant says, I need to leave, or an occupant says, I'm leaving, or a roommate who is not on the lease or is on the lease says that I am leaving. And it is, of course, like with collection calls from law firms and debt collectors, really an extremely good idea, ideally, although this is generally hindsight, for someone to have a record of communication. What was said by them, what was said in response, who said those things, where that conversation took place, how it took place by telephone, in person, by email, whatever. And of course, if there is a physical record or an electronic record that can be created, like with an email or a letter, you retain that record, you create that record. As you guys know, there is now a duty to mitigate. That is a common issue that we deal with in these cases. And a duty to mitigate is something that exists as of 2019. It is possible to still now have a case from 2023 that for various reasons sat in civil court for a long period of time and still is an active case and may partially or perhaps still possibly not at all involve a duty to mitigate. But generally speaking, given that it is 2026 now, a duty to mitigate should be applicable in a majority of rent arrears cases. And so that is, of course, again, like with constructive eviction and implied warranty of habitability and other issues that we were just talking about, a defense that can and should be raised to a rent arrears collection proceeding with the landlord. So all of those defenses that exist are defenses that can be raised. So I'm not going to spend too much time on this, given especially that it's 3:20, and obviously I have a penchant for going on and on and on about things. These are defenses that you all most likely know, and that can be asserted in civil court just as much as they can be asserted in landlord-tenant court for these rent arrears cases, right? So payment, obviously, constructive eviction, anything related to the legality of the premises or the lease itself. Surrender is, of course, a defense. Third-party payment or third-party obligations is a defense. An incorrect amount of rent is a defense. A return of the security deposit is essentially a counterclaim, but is a defense. Implied warranty of habitability breaches are defenses. Repair costs are defenses. et cetera, et cetera, et cetera. So these are all defenses that can be raised in these proceedings. We do spend a decent amount of time on senior citizen and domestic violence survivor defenses. A lot of people do not know that those defenses exist, or they might know older versions of the defense, particularly in the case of the domestic violence survivor defense, which was improved substantially a few years ago. It is always very helpful, especially because civil court judges do not necessarily have a ton of experience with landlord-tenant proceedings. And anyone who might be talking to these individuals about their rent arrears cases may not have a ton of landlord-tenant experience to help someone flesh out their specific defenses, talking about documents that they might need, evidence that they might need, putting together a timeline, all of those sorts of things. Those are things that I think can be extremely helpful because these are often very difficult situations because, in part, you have a bad financial problem. Oftentimes, obviously, if someone is facing eviction from their current premises, there are some financial options through the city and through other organizations that can exist to deal with rent arrears and keep someone in their premises. Those options basically evaporate once someone is no longer in those premises. That is viewed as a monetary dispute. But it is obviously not the case that that is simply that, because what you would be asking someone to do in a lot of these instances is pay 1.5, 1.25 times their rent. They're paying their existing rent to their existing landlord for their existing premises, and they're trying to settle this debt that they have for this other landlord who wants potentially tens of thousands of dollars in rent arrears or damages or whatever the case may be. And so working out a repayment agreement is very difficult. If you went to HRA and said, I need a one-shot deal, they would say, what is it for? And you would say it's for rent arrears for an apartment I am no longer in, and not to, say what HRA is going to say in every single case or something like that, but they're most likely going to be told that is not an emergency, please leave. There are other people who have more pressing problems, and we're going to be helping those people and not you. But that creates obviously a problem for settling these cases. And so that situation is a real issue relative to situations that might exist in landlord-tenant court. The other thing that is going to be an issue is that there is going to be, for most people, if they don't have any issues related to implied warranty of habitability or constructive eviction or something like that, an issue of use and occupancy. And civil court judges are going to expect that if someone was actually in the premises, that there is a strong equitable use and occupancy claim that a former landlord has, and that there needs to be a financial settlement of some kind. And generally, a financial settlement that is relative to credit card cases, and especially third-party debt buyer cases, very advantageous for the landlord, and something that's going to be very hard to swing if you are this former tenant or former occupant. And so that is a real problem in these cases because, again, obviously, if you have rent arrears, you can have rent that is $1,700, $1,800 in parts of Brooklyn. You can have rent that is much more expensive in other parts of Brooklyn. And so if you're talking about 7 or 8 months, you can very easily get into $20,000, $30,000, $40,000 in rent arrears, damages, attorney's fees, et cetera, and reaching an agreement on some part of that amount of money, depending on the defenses that your client or the person that you're speaking with may have, could still be extremely difficult. So it is extremely important, A, to assert all of these defenses to make your case to the judge, obviously, as to why the money owed is not correct, and B, to, assert those defenses to the plaintiff. It may be that you actually are the kind of person who wants discovery to be exchanged so that you can say that you put the landlord on notice of all these things that they forgot about 5 years ago when you were in the apartment and there was an issue with hot water, or there was an issue with bed bugs, or there was an issue with rodents, or there was an issue with a roof that was leaking into your apartment from 2 floors above, or you were on the top floor and it was damaging your bathroom, and it was damaging your bedroom, or it was damaging your child's bedroom. All of those things are things that you want to put together, as I said, and especially compared to creditor situations that we generally deal with, press discovery. Generally, when we are people in helping people in credit card cases, there is absent identity theft and some other defenses, not necessarily a ton of discovery that they want to provide to the creditor. The rent arrears cases are an exception to that because generally people have broken leases or have these claims against them, and there are plenty of problems that they had with the premises. And the landlord is trying to blow right past those things in court and just get their contractual rent times the period of time that they say they were not in the apartment and forget about all of the other issues that oftentimes led to the person quitting the premises finally at long last. And so you want to make sure that they're reminded of those things, that they bring those things up to the judge. And then obviously you have counterclaims. Those are things, of course, that you're going to have to prove because those are claims that you are making against the other side. So the burden is on you, the former tenant, to prove those things. But those are things that you can assert, right? So security deposits, overpayments, damages, repair costs, those are all things that are counterclaims that can be used to set off a claim by the landlord for rent arrears, or every so often you will say, I had this expense and that expense and that expense, and it is worth more than what the plaintiff is asking for. And you say, actually, since you're the one coming here, it turns out that you really owe me. And that's what I think what should happen in this case. That's pretty rare, but it does happen. And so those are all things that you can put into your answer as a former tenant or a former occupant that are all in housing court. They're all still valid in these civil cases. All
And
right. Yes.
would you be able to discuss briefly, like, I don't know if you already talked about it, but if you have a co-tenant or like, and you guys were like roommates and one person was to pay, and how that affects, how that plays out in when the landlord takes you to both to court.
Yes. So often we do not see the landlord take everyone to court. We see the landlord take to court people that they can find and that they think are the moneyed occupant, lessee, whatever, of the premises. So there will be a roommate situation in a 3-bedroom and one or two people are sued and not all three people because the landlord has a good idea, and probably they're right, although I don't honestly know because that person's not there and I have no idea. Probably they're right that that person is never going to pay up, and it's not even worth trying to bring them into the lawsuit and spending the money on serving them with process. From there, it is going to depend on the factual situation that presents itself regarding the lease itself, if there was one, and the conversations that were had between those parties. Sometimes it is the case that roommates are on the same page. They both come to us, they have the same story, and they want the same thing. Often that is not true. And then we have an issue with obviously representing people who have different interests and figuring out, whether there's a conflict, whether that conflict is something that is resolvable or not, and then figuring out from there, what's going to happen with the rest of that case. But generally speaking, excuse me, that is really going to be based on the conversations that were had with those roommates about who was, taking over for those issues. It may be the case that if there were, that 3 roommate situation and there's a roommate who's not sued, who agreed to take on the obligation, that you potentially, although this is not something that we would generally do, and it's going to be an attorney that you would need to do that, you can bring them into the case. That's called impleader. And so you'd bring them into the case and say, hey, I'm not the person who's responsible. This is the person who's ultimately responsible. You didn't bring that person into the case, so I'm bringing them into the case. We have that situation come up with regards to medical debt actually relatively frequently, even though, again, it's not something that we really are equipped to do as a limited provider through Volunteer Lawyer for the Day and Claro. So people will go to most notably dentist offices, and a dentist will say, you need XYZ treatment. Here are some forms. Let's start filling out these forms. And someone's maybe under some local anesthesia or not, and they're sitting in the chair and they maybe, have something in their mouth, and they're like, sign these forms. They start signing forms. And then they say, okay, I'll see if I can do this. This is a lot of money. I'm not sure if I'm going to be ready to do this for a little while, whatever. Let me leave and think about it and I'll get back to you guys. And then sure enough, 5 months later, 9 months later, whatever, they start getting statements from a credit card company saying, hey, you applied for $4,000 with us for a medical credit card and you haven't paid us. You need to start paying us. And they will have some issues with that because very often they will say, well, what I received was substandard services and they never corrected it, or I never received those services at all and I didn't agree to apply for that credit card, especially when I hadn't agreed to do the services yet. And that dentist or medical provider of some kind will not be a party to the case because the credit card company will say, you signed this agreement. This agreement is between us and you. So our dispute is is with you, is not with anyone else. And you need to bring that third party in. It's a challenging situation, but that's something that could potentially arise depending on what's going on there. But otherwise, it depends a lot on who is coming in to talk to you and what they're saying the situation is, and are other people willing to get involved in the case to resolve the case, and what are they saying the situation is. It's hard to say sort of more specifically than that, kind of what's going on there. But it is something occasionally that comes up. A lot of what we see is people having vacated the premises as a family, as a couple, as an individual tenant, and they have reasons related to the quality of the apartment, or just non-renewal of the lease, or they vacated the premises for a permissible reason, like they're domestic violence survivors, as I was mentioning, or because they moved into senior citizen subsidized housing, and the landlord, didn't pay attention, doesn't have the paperwork, didn't respond to the defense, and is just bringing a lawsuit, trying to collect some money. We see a lot of that. Anyway, so we have about 15 or 20 minutes. I was going to talk to you guys. Whoops, I'm sorry. We do have time for questions, but I was going to go up and see otherwise if people want to hear a little bit about service of process, because that is very different in oops, I'm sorry, I did it again. Landlord-tenant cases than in civil cases. Landlord-tenant cases, right? You're talking about a notice of petition and a petition. And you're talking about service of those papers that's governed by specific parts of state law. For the rest of civil court cases, you're talking about Civil Procedure Law and Rules CPLR 308, which is the regular service of process statute of a summons and a complaint. That is a strict compliance statute, and there are frequently, especially in civil court cases, again, where the money is relatively low for the parties, or at least for the plaintiffs, I should say, and relatively low for jurisdiction of the courts, because the courts, of course, in state court, you can go up to, whatever amount of money there is. And in civil court, the jurisdiction is $50,000. A lot of poor service. Most of the time, and analyses bear this out, most of the time civil court judgments end in default judgments when someone does not have an attorney. There is no service of process that is proper, that is affected. There's an affidavit of service that is filed, and there's a default judgment that results. And that is, especially in consumer credit cases, true a majority of the time. And that is obviously a humongous problem because we are an adversarial judicial system. And so the whole point is, if two sides have a dispute, one side starts a case, they notify the other side, and everybody has to make their arguments in front of the judge. The judge is not going to do her or his own investigation into what's going on the way that you might see in other legal systems and then render a decision that's fair based on their own research and analysis. They expect the parties to appear and make the arguments that they need to make based on their positions. And then the judge, properly informed at that point, makes a decision, right? And so if you have bad service, then you don't have the other side there. They can't make any of those arguments, and you end up with a one-sided story and default judgment that may not make sense. And that happens an astounding percentage of the time. And so service of process is an issue that we talk about all the time. In a civil court case, obviously, regardless of who the parties are, 308 is the statute that matters, and it has to be strictly complied with. So if there are issues with service of process, then generally speaking, those cannot be fixed. That is a lack of personal jurisdiction for the court, and the case will be procedurally dismissed. Then if there is multiple dismissals or it's out of the statute of limitations, then that case can't be brought again. If it's the first dismissal or there's still statute of limitations that hasn't run yet, then they can bring another case. It's just a procedural dismissal, but it is a very effective tool for litigants, meaning defendants, for us, obviously, a very effective tool for them to deal with people who are otherwise acting, as I feel, a little bit unscrupulously. So very, very quickly, service or process. Service or process can be done for the people that we're talking about basically in three ways. One is you find somebody, right? If I am, or NEPA is suing me, right? And NEPA hires a process server, and the process server finds me out on 73rd Street and Lex in Manhattan and hands me the papers. Good service, right? I am found, they gave me the papers. Great, done. I don't get to argue about that, right? That is personal service. That is section 1 of 308. You can do that. You can do that anywhere that the person may be found. 308.2. If you can't do that, and the vast majority of the time you can't do that, then you can go to one of two places. Their residence, which is the actual dwelling place or usual place of abode, or their actual place of employment, and you can serve someone of suitable age and discretion there. So in other words, if NEPA is suing me, NEPA hires a process server. I'm having a party, and NEPA knows my address because she is my former landlord, and I gave her my address when I left or something like that. And I invite Adriana to the party. And Adriana invites a friend who I have never met before. And we're having a party. It's all great, awesome. Process server comes that NEPA has hired. If Adriana's friend, answers the door, and she is of suitable age and discretion, meaning that she is not drunk or under the influence of any medication or has any mental conditions that would affect her understanding of these kinds of proceedings. And she is, generally speaking, older than 14 years, although in New York it's a little bit vague. And the process server hands her the papers after knocking on the door of my apartment, and she opens the door. Is that good service? Yes, that is good service. Even though I have no idea who this person is, I didn't tell Adriana you can invite anyone or anyone specifically, and she has no idea who I am, and she may not give me the papers. That is still good service because she is a person of suitable age and discretion, and she has been served at my actual residence. Similarly, right, if NEPA is suing me and NEPA hires a process server and I am at work and Adriana is the CEO of the company and she is sitting in a chair near the front door and a process server knocks and Adriana answers and says, hi, and they say, I have papers for you or for Aaron. And she says, okay. And they say, who are you? And she says, I'm Adriana. And then you say, what's your title? So I'm the CEO of this company. Is that good service? Even though it was not me who received it and Adriana doesn't necessarily give me the papers. Yes, it is, right? Now, if I work at Walmart and Adriana is my coworker and NEPA is suing me and they give it to Jeff, who's a customer at Walmart, is that going to be good service? Of course not, right? If someone is outside of my apartment, like Adriana's friend on a lawn because we live in the suburbs and we don't live in New York City, or they're out on the street in front of the apartment building, and there's a party and Adriana was invited and she invited her friend, but they're out on the street and the process server comes and they say, do you know Aaron? And they say yes. And they say, are you aware if he's at home? And they say yes. And they say, can you give him these papers? And they say yes. And he gives them these papers to give to me. Is that good service? No, that is not good service because you are not actually in the dwelling place or usual place of abode, my residence, at the time of service. But otherwise, they can give those papers to those people at those places. And that is called substitute service. That is section 2. And then they have to mail within 20 days a copy to my last known residence and file an affidavit of service. In New York, there are obviously lots of large apartment buildings. All the time, people come to us and they say, I found out about this case that a company started against me, that Citibank started against me, or TD Bank started against me. And I found out about it because my neighbor had papers posted to their door and they gave them to me. They knocked on my door and said, hey, these papers were on my door, they're for you. Or my neighbor knocked on my door and said, hey, there's some papers on the floor. They have your name on them, they're for you. Or I found it in my mailbox and I never knew anything else about it. Or some guy I didn't really know was walking past me in the hallway and said, hey, there were papers taped to the inside door of our building and they had your name on them. You should go find those. I think it was a court case. None of that probably is going to work. But what you need to do is you need to have someone get the affidavit of service and figure out what the process server swears under penalty of perjury happened that is in compliance with 308 of the civil practice law and rules. And if there is something wrong because they went to the wrong apartment, or because they put it on the inside door and not on any person's particular apartment door, and it's an 18-unit building or a 200-unit building or a 4-unit building or whatever it is, or they or someone didn't receive it at all, and you want to see the affidavit of service, you can rebut that and you can vacate a default judgment, and you could potentially dismiss the case. And if it's outside of the statute of limitations, they will never ever see it again. But the way that you do that is that you get the affidavit of service and then you argue against what is in the affidavit of service. So someone cannot just say, I didn't receive the papers, or I received them only by mail, or my neighbor saw them on their door, and I want a traverse hearing where the process server has to come, or I want this case dismissed. That is not going to work. What you have to do is you have to pull the affidavit of service. And that's why it's so important, as I was mentioning, I don't know, ages ago when we were talking about this, that we get access to those documents. Because if there is not an affidavit of service that we have, then we can't make that argument. You guys can't make that argument. The consumer cannot make that argument. The defendant cannot make that argument because they're not arguing against what the process server said in the affidavit of service. They have to have that information. Now, if there's a very old case, and the company that sued can't get the affidavit of service, done. That's it. They don't have the affidavit of service, doesn't work. Sometimes they're at the mercy of court files the same way that our clients are at the mercy of court files. Otherwise, if they have an affidavit of service and it has an error in it, like your client lives in 4C and they served 4D. Your client lives at 1948 Saratoga Avenue and it says 1984 Saratoga Avenue. Or there are lots of very specific rules based on this. They have to do a mailing within 20 days, and it doesn't say when they did the mailing, or it says they did the mailing, but it doesn't specify the address to which they did the mailing. Those are all deficiencies in the affidavit of service themselves. Those cannot be fixed, and the case should be dismissed. But the only way you're going to know that is by getting the affidavit of service. So your touchstone is really the affidavit of service. Does it exist? What does it say? Is it completely filled out? And then you go on from there. Otherwise, the third option is what we refer to as nail and mail, which is something that you guys are more referred to because it's most akin to service of notice of petition and a petition. If a process server has exercised diligence in trying to serve someone at the residence or the place of business, or they say they can't figure out one of those two places and they try the other place, and they swear to the times and dates that they tried to make that service and couldn't reach anyone, then they can post it on the door and they can send a copy by mail. And that's nail and mail. And then you can, based on the affidavit of service, figure out if those service attempts constitute reasonable diligence or not. And then so whether the service is good or not. And so there are all kinds of situations that exist where you can figure that out, right? If that's not your address, and you have proof that you moved, then that's a great example, right? So all the time we will see rent arrears cases and someone has left the premises, and it's strange because they might have emails from the management company that just say, okay, when they said, I'm leaving the premises effective October 13th, 2023, or whatever it is, and they'll get an okay, and then a case will be started, and what's the address of service? It's the old premises. You're like, of course, this doesn't work, right? So if this is not your address, then the first thing you say is, well, you tried to serve someone at my place, or you did nail and mail to my address. That is not my address. Here's my address. You cannot just say that in an affidavit. You have to provide some documentary proof. So that means lease for your new place or mortgage for your new place. We had someone who is still fighting a rent arrears case, and they purchased a property in 2019 that they've been saving up for years and years and years. So they finally are getting out of leasing. They're bought a house in New Jersey, and they left and they tried to get out of their lease. And the management company was basically like, forget you, you have to pay for the rest of your lease, which ran into April of 2020, I believe. And They wanted to move out in, I think, like July or August of 2019. And so eventually they were like, forget it, fine, we will pay the extra 8 months. And they paid the extra 8 months and they left. And lo and behold, the management company has sued them, or the landlord has sued them for rent after their lease ended in April 2020, saying you were still there and you signed a lease after that. And they're like, this is insane. Here's the deed for my property in New Jersey from over a year ago. And I wanted to leave and I emailed you so many times, can I break my lease early? And you said no, but you knew I was leaving. And so not only did you know I was leaving and I wouldn't sign a lease and I wouldn't be paying rent, also I don't live there. And where have you served me? You've served me at that apartment that I was telling you desperately in July, summer of 2019 that I wanted to vacate. So if that's not your address, what do? You show up with your deed, right? You show up with your deed and say, I did not live there at the time of service. I lived at this place. So anything that you sent to someone there or that you posted on my door there is going to be bad service because that is not my actual dwelling place or usual place of abode, my residence. And so that is not proper service. There are tons and tons of cases about all of the different situations that people find themselves in. But the basic point is there are tons of issues of service in civil court. Lots of people end up with default judgments. There's not a reason that they necessarily can't challenge the service, but you have to get the affidavit of service. You have to figure out why it's wrong. You have to provide a specific affidavit rebutting that. And you're going to have to do that in an order to show cause to vacate a default judgment and dismiss the case for improper service. That is something that, in terms of starting an order to show cause, people can do on their own at the clerk's office. So in Brooklyn, that's the third floor clerk's office. All the time, people come to us and they have orders to show cause for a default judgment in a 2019 case or a 2022 case or a 2011 case, because we're getting close to the end of statute of limitations and the plaintiff is desperately trying to find any sort of money to extend the life of their judgment. And now they've found a bank account and they've restrained it, and the client has finally learned of this judgment and they want to figure out what's going on and vacate the default judgment, dismiss the case. And they go to the clerk and say, hey, I have this notice of restraint or I have this notice of garnishment. I don't know anything about what's going on here. I want to vacate. I want to, this case is not a valid case. I want to get it dismissed. And the clerk will give them an order to show cause. They'll fill out the order to show cause. And the clerk, again, just to go back to a point that I've been mentioning several times, does not have the affidavit of service. And so what happens in those situations is a defendant cannot rebut the affidavit of service if they don't have it. Right? And if they don't have the affidavit of service because they never received any court papers in this case, you don't generally receive an affidavit of service anyway, but they had never received any court papers in this case, and the clerk doesn't have it, then they can get their order to show cause signed and they can start trying to reopen that case and dismiss that judgment. And the plaintiff has to oppose that order to show cause, and they have to provide the affidavit of service. And then from there, you can start figuring out what's going on and rebutting. But if they have a notice of garnishment, or an income restraint, or an asset restraint, and they want to get the process started right away, so none of that money leaves the income that they're supposed to be getting or the bank account that they need to have access to pay their next month's rent or pay their other medical bills or whatever it is, then they can file an OSC. And if the affidavit of service is not available, then you go ahead, you get everything frozen, you notify your employer and the marshal and the attorneys for the plaintiff, and then you start figuring things out from there. And so that's what's done at the clerk's office. Doing the basics is, generally speaking, a very simple thing to do. Obviously, it would be sort of preferable, if you have an attorney from the get-go so you can figure out what's going on, but the vast majority of people aren't going to get access to that. And so the important thing is to file the OSC and notify everyone who's involved so that none of that garnishment happens. And then you can sort of piece together things from there, generally speaking. Okay, so that is everything that I have for the moment. I know that was a whole lot of talking. I appreciate your patience. If anyone has any more information that they would like, please ask me a question or send an email to help and it'll get sent to me and I can answer that question. Or ask your questions now in the 5 minutes we have left. And I'll say before we get off, thank you very much for attending. And I appreciate your time and appreciate the work that you guys do to help everyone across the city get access to the things that they need and help prevent unscrupulous people from putting things over on the people of Brooklyn, people of New York City, excuse me.
Thank you,
Yeah.
Erin, so much. This has been amazing.
Yes, definitely. One question. So if there's a garnishment,
Mhm.
and it's making it unaffordable for you to like maintain, like your living expenses, is there any way to request a reduction? Like you're not contesting the money, you're just saying, I can't pay this much at the same time.
Generally, no. Generally,
Mm.
no. It's 15% if you are making more than the minimum wage. If you're making less than the minimum wage, there is no amount of money that's supposed to be garnished at all. So if you're making $30 an hour, but you're working part-time and your average weekly take home is less than the minimum wage, shouldn't be garnished. If you're working, but you're making $15 an hour, which is now less than the minimum wage, and you shouldn't be doing that. But if you are, then you shouldn't be garnished at all. Um, so that shouldn't happen. If it is happening and it is valid and you're not contesting the judgment, your option is going to be filing an OSC to stop that garnishment. You send that to plaintiff's counsel, you send that to the marshal. I would send it to your employer's HR so that they stop doing the actual withholding of the money from your weekly or biweekly or monthly paycheck. And then you'd go into court and negotiate and try to find something that is going to be workable for you. Because otherwise, legally speaking, um, no, the answer is no.
And then for situations where there was a money judgment for like a legal spouse, and then there's either a death or divorce, does that change who owns it, or is that just dependent on like the divorce or?
Yeah, that's a good question. So a divorce is supposed to separate the obligations of the parties, and that is supposed to apply equally to debts as it is to assets or future income in the form of spousal maintenance or child support or whatever. Um, so a divorce decree should have language in it about the debts. Sometimes it doesn't. Um, there could be an uncontested divorce and they submitted a paperwork and it doesn't deal with it, or there's a judgment from a contested case and it doesn't deal with it. And then it's going to be very hard if the debt was actually for the unnamed former spouse. It's going to be pretty hard to try to bring them in. Um, if otherwise it is dealt with in the divorce and you're not supposed to be legally obligated, then your defense is a documentary defense based on the judgment of divorce, and that's a motion to dismiss based on documentary evidence. So that should be pretty good. But if it doesn't deal with that, and a lot of times it doesn't, to be honest, that's hard. That's hard. Um, if there are multiple defendants, then the death of one of those defendants, like if you had your grandmother as a guarantor on your student loan or something like that, and she passes away, then they have a claim on the estate, potentially. Very often that comes to naught and they don't pursue those sorts of things. Um, and they will probably just bring a suit against the other person. Or, if it was your grandmother's car loan and you co-signed on her loan because you were working and you made money and she passes away, then they could come after you as the guarantor, even though functionally it wasn't your vehicle and you didn't have anything to do with it other than making sure that she could get this loan that she otherwise had the money to make payments for, because they wouldn't give it to her otherwise. Um, there's a claim against the estate that, generally speaking, doesn't really ever result in anything because most people don't have estates with liquid assets at the end. Um, they could pursue a case against you. But otherwise, if your spouse passes away, right, um, they don't get to pursue you, right? Just because you were the spouse. If it's in the name of that person, it's in the name of that person. They can make a claim if there is an estate against the estate, but it doesn't otherwise have any bearing on you. I don't know if that answers your question or not.
Definitely. And just one last question. Is there any special protections for domestic violence victims?
So, not yet, but very soon. There was a bill that was just passed, that it was a result of very hard work by lots of people, that doesn't include me, although we are extremely supportive of it and are looking forward to using it in cases that does establish these protections. As of now, there is not a protection. We make those arguments informally in court, especially if there is documentary evidence of that domestic violence, right? Obviously, you're generally talking about orders of protection, but there can be other things. Um, you can make those arguments. But is it a legal defense, like the hardship argument that I was talking about, where you're trying to voluntarily discontinue a case because someone doesn't have a lot of money and all of it is from an exempt source that they can't get, even if they get a judgment? No, it's not a legal defense. But very soon there is. And Canva Legal Services and some of the other organizations, URI, that were involved in the passage of that bill just did a training, and they should be sending out notes very shortly. I believe it becomes effective in June, and I'm not sure of the exact date, but it's this summer that that protection will start coming into play. So from that point forward, yes. But as of now, unfortunately, no. But I would still make the argument. We make the argument all the time for hardship, for discontinuances based on hardship because someone has a medical condition or their family member has a medical condition and that person is their sole caregiver and can't work and earn as much money as they otherwise would, or because their only source of income is, pension or something, and that's protected. A lot of times the plaintiffs say no, and certain plaintiffs say no all the time, honestly. But we still do it. So I would still make the argument now anyway. Every so often it comes together, but it'll be a lot more effective, obviously, once there's legal backing behind it.
Great. And thank you so much, Erin. This was a very helpful training. I'm pretty sure we all learned, um, a lot about it, especially the service process, because it's so different from like housing court procedures. But thank you again, and have a great weekend, everyone.
Thank you.
And
Thank you,
I
everyone.
believe like this is the contact information for anybody who's here on the phone. You can contact Access Justice Brooklyn at 718-624-3894 or email them at help@accessjusticebk.org. But yes, thank you again and have a great weekend.